This is going to be Chapter 6, the Law and Paramedics. After completing this chapter, you'll be able to understand the origins of case law, civil and tort laws and the elements of a lawsuit, the complexity of patient consent, both legal and ethical concerns, the understanding of patients' rights, principles of advanced directives, and acts and laws that impact the paramedic as an employee. So, the origins of law. Now, in the past, kings decided sentences and issued edicts, and the rule of law began. When cases became too numerous for the king, magistrates were appointed to handle minor cases. They would judge the worthiness of a case and render a judgment. The resolution was reported to the king. Now, over time, judicial cases were documented and became case law. They were arranged by date and jurisdiction and used as references in future cases. When democracy came around, this required a new means of public policy. Legislators were elected to create new laws, examples of this were statutes, and represent the people of a given area. An example of this would be like a senator. Government units or departments were formed, and they performed various functions. Rules and regulations carried the same force of law. Now, when a violation occurred of this, an investigation to determine the court and determined in court having authority, the department, the petitioner, brings charges against the wrongdoer. The respondent, in this case, instead of plaintiff defendant, respondent is notified to appear, and the hearing is conducted before an administrative law judge, and the administrative law judge renders a decision. And criminal law. Criminal law was a good thing whenever it came around. Replace personal vendettas and blood feuds between groups of people. Without criminal law, if a large enough group of people didn't like what you were doing, they could pretty much lynch you. Successive acts of vengeance were prevented and order was maintained due to this. A crime is defined as an act done in violation of a person's duties to the community and for which written law requires the person to provide satisfaction. Once these were defined and codified in criminal law, a person is charged with a crime. The prosecutor is the state, and the person is tried in criminal court. And an example of this would be the state of Oklahoma versus, say, Roy Smith. Now, criminal court systems, there are a couple different kinds here. There's state, federal, and supreme. The state court pretty much handles violations of state laws. The federal court handles violations of federal laws. There is an appellate court as well, or an appeal court. Courts determine appeals from decisions of trial level state courts. Requests for the appellate court to change the decision is issued by the trial level court. The highest level and the higher level court, one just above wherever you were tried at, if you were trying to appeal it, could overturn it. The highest level of court in the U.S. is the U.S. Supreme Court, and that is the last court of appeal. Civil law. Civil law revolves conflicts between individuals. Common matters, contracts, torts, estates, trusts, wills, real estate, commercial matters, and grievances against the government. A tort is, the definition of a tort is a civil or private wrongful act other than a breach of contract, resulting in some type of injury or harm. An intentional tort is an act which causes harm. An example of this would be an assault and battery or false imprisonment. Public trust is another term in this section. Involves an understanding between the patient and paramedic that the patient will be treated with dignity and respect. And negligence. Negligence is failure of the paramedic to exercise the degree of care that a prudent person would exercise. And there's two different kinds of neglect. There is simple neglect, which is the lack of ordinary care, the lack of standard of care, and gross negligence, which involves intent. So if gross negligence was involved, the intent was on doing whatever was done. That could be if you were doing harm or whatever. Those would have been done intentionally. May result in charges of malpractice if neglect is charged. Elements of a tort. An element of a tort. For a tort of malpractice to be the basis of a lawsuit, it must have the elements of a tort. And in those, first of all, there must be a duty to act. And then we'll define this here really quick. The paramedic has a duty to act whenever the paramedic is called to perform patient care. A normal citizen does not have a duty to act. Once the duty has been undertaken, the patient can reasonably expect continued care until the care can be turned over to another provider. Premature termination is known as abandonment. Abandonment is essentially the act of turning away. And an example of this the book brings up is physical exhaustion is not considered abandonment. So physical exhaustion would be like I did CPR, I was by myself until I could no longer function. That is not abandonment, that's physical exhaustion. Good Samaritan Act. This encouraged rendering aid during emergencies. A Good Samaritan doctrine was established from the Bible story of the Good Samaritan. The laws protect well-meaning healthcare providers that provide assistance outside of the duty. However, this does not provide you with immunity, and it may not apply if the paramedic created the situation. An example of this started an external jugular IV and blew this guy's lung, or created a tension pneumothorax or a pneumothorax. That would be actionable. Breach of duty occurs when a paramedic does not perform the standard of care. So you've had a duty to act, and you have a breach of that duty. The standard of care is established in court. Then a breach of that standard is determined. So this is up on the big screen, your PCR is up there, and they're determining first of all, what the standard of care was, and then how you neglected this. A couple terms in this is misfeasance and nonfeasance. Misfeasance would be the paramedic performed the correct procedure, but it did so incorrectly. And nonfeasance, the paramedic fails to perform the correct or required procedure. So, saw the clinical indication for it, but just didn't do it. Would much rather run to the hospital instead of perform their job. Damages. To be actionable, or to be the basis of a lawsuit. The patient must have experienced some injury or harm. Damages are compensation for suffering, injury, or loss. Compensatory damages, economic damages can have a fixed price. Non-economic damages are compensation for intangibles. Those are going to be things like pain and suffering, loss of life, intangibles. Punitive damages, similar to a civil fine, this is intended as punishment for poor conduct or sending a message to others. Proximate causation. A tort requires that there be a duty, a breach of that duty, and an injury as a proximate result. The plaintiff must prove that the paramedic's actions were the proximate cause. In contributory negligence, the paramedic is responsible only for a percentage of the damage because he contributed to the neglect. Borrowed servant doctrine. A paramedic has the highest level of education or experience on the field. When the paramedic accepts assistance from other EMS providers, vicarious liability occurs. He also accepts responsibility for the actions and the errors of those providers as well. A process of civil lawsuit. Now this is a pretty long and lengthy process. We'll talk about each step of it. The first of all, the attorney initiates legal proceedings. The patient approaches the attorney and the attorney initiates legal proceedings. Then papers are served. A process server is hired to deliver the papers. Once the matter is pending in court, the plaintiff or defendant could then ask the court to make a decision based on the facts. The judge acts as the fact finder, and then summary judgment could occur. And this is a determination by the judge solely off of the papers without conducting a trial. Pretrial discovery. A subpoena, a legal command to appear. The patient may authorize through a written release of information the paramedic's patient care report be released to the attorney. Now, every report must be authenticated before it can actually be entered in the court records, so a notary public has to authenticate those documents. Affidavits can be taken, those are sworn written statements, or deposition could be taken, those are swearing on oath, and generally a recording, whether by stenographer or tape. Settlement. An agreed sum of money is paid when the trial may be counterproductive, difficult, or expensive. So a settlement can occur because a great expense could occur between companies. They've agreed on it. It could be difficult to prove, or it could be expensive. So sometimes an agreed sum of money or a settlement is occurred at this point. Quality assurance and discoverability. Quality assurance is there to improve quality of the overall standard of care. Efforts to improve patient care through uniformity and reliability with the standard of care, often accomplished through retrospective analysis of the PCR. And this is done after the fact. So after the PCR has already been generated, or the patient care report, then quality assurance will take a look back through the patient care report and see if there's any adjustments they can make. Immunity and defense. Person or entity is exempt or cannot be sued or held responsible for torts. And an example of this is going to be governmental immunity or sovereign immunity, means that the government's pretty much exempt. And also immunity is granted whenever a paramedic is required by law to report a crime, a mandatory reporting, and they do so in good faith. Motions in court. Requests to the judge for some kind of action is what a motion in court is, and this can be verbal or written. Summary dismissal is made when the time exceeds time exceeds the statute of limitations, and negligence per se is another term in this section. Case where summary judgment might be granted for the plaintiff. Patient consent. Paramedics have an ethical and legal responsibility to preserve the rights of the patient, and there's several areas here that we're going to discuss. One is self-determination. The importance of preserving patient autonomy and self-determination. So they have rights that we cannot infringe upon. They have constitutional rights that we cannot infringe upon. First of all, we're going to talk about autonomy. So autonomy is you are aware of yourself. So any kind of thing that would infringe on the person's autonomy could be held as legally as trying to infringe upon the patient's rights. Disclosure, an open dialogue between the patient and the provider, and the provider tells the patient about the procedures or anything that would be done to them, including the risks, recommendations of the procedure to the patient, and any foreseeable harm is all explained in this, that you have full disclosure. Understanding, patient must be of sound mind, patient must have legal capacity to understand, and in general, the patient must be of legal age. They have to volunteer or voluntariness as well. Patient consent must be voluntary, and the patient cannot be coerced into consenting. So you can't throw them into an armbar to make them consent. Permission, following the explanation and opportunity for the patient to ask questions. The paramedic should ask for permission to proceed. This is usually done verbally, and be sure that there's witnesses present. Additional concepts of patient consent. We're going to talk about barnacle on the next slide. It's right after this one. But it's a way of delivering the patient's options for consent. An emergency exception. Delay may compromise the patient's health, so in some cases for consent, an emergency exception can be made. An emergency exception may clearly be a benefit to the patient during a crisis. However, not every EMS call is an emergency. Therapeutic privilege. In rare instances, it is acceptable to withhold information from the patient for the patient's benefit. This would be when disclosure would pose a threat or detriment to the patient directly or their direct health. Waiver of right or consent. Some patients will summarily waiver their rights to consent. Permits the paramedic to treat the condition to the standards of care. And an example of this would be for the patient to say, just go ahead and do what you think is best. This is barnacle, and this is table 6.1 in your book. Benefits of the procedure, alternatives to the procedure, risks of the procedure, nature of the procedure, answers to the patient's questions, if they have any, consent to the rights of the patient, lack of treatment consequences, and then explanations are understood. So I think that this is a benefit to you because it could save your life. You have alternatives to this, but I would not suggest them, and this is why. There is a risk to this procedure. Here's what we're going to do. Answers to any question that you might have, consent to the rights of the patient, that they have a right to choose, and that you have obtained consent. An example of this, so do you understand everything that I've said here? Is it okay that we go ahead and do this? Lack of treatment consequences, if you don't do this, this might be something that would occur. I don't have a crystal ball. I can't see into the future. However, I think this, in my professional opinion, this needs to be done. And then all of your explanations are understood. Advantages of consent. It does some very simple things for us. It protects the patient's right to choose. It decreases the danger of any kind of complaints, and it provides reassurance. Types of consent. There is expressed, implied, involuntary. We're going to talk about emancipated minors, and then pediatric consent. So first of all, express consent. During an emergency, a patient allows a paramedic to initiate care and indicates consent by either gesture or verbal acknowledgement. So you make some kind of gesture or verbal acknowledgement that says, yes, I would like you to help me. Implied consent. Used whenever the patient is unconscious and unable to speak for himself. So if he's completely out and he can't speak for himself and tell you that he would like you to help, assumes consent if the patient were awake. Involuntary consent. During life or limb emergency, an officer can provide consent for the patient in custody. Emancipated minors. Patients below the age of majority are permitted to give informed consent. And there's some very stringent stipulations on this, and it depends kind of also from state to state, or what the state would suggest or would say that this is an emancipated minor. Generally, military service, you've provided for yourself greater than 6 months and been on your own, or you've went into the military. Any of those emancipate you. Pediatric consent. Parent or legal appointed guardian must provide consent. The pediatric consent without a parent. If the child is hurt and no parent is immediately available, the adult left in custody of the pediatric patient has the authority. If no adult is available, emergency doctrine may be used, and this would be a form of implied consent. In rare cases, the parent may refuse treatment and transport for the child. If you think this would be detrimental to the child's health, an officer may take the child into protective custody. Medical restraint. Behavioral emergencies may call for medical restraint. Each state has mental health laws that provide for involuntary restraint. Following restraint, the paramedics must periodically reassess the patient and document restraint use. Positional asphyxia. Sometimes during a restraint, a patient may become so agitated and combative that they will enter a state of excited delirium. They become hypoxic. This process is called positional asphyxia, and then they subsequently go into cardiac arrest. Please reassess your patient frequently. This is an example. Proper use of extremity restraints in opposing directions. And then patients should not be hogtied, and this is hogtied. Very difficult, depending on their weight, that they can get air into their lungs. They easily become hypoxic and may go into full arrest. Refusal of medical assistant. Every patient has a right to refuse care. Exploration of this reason that they have may resolve this reason. Examples of this, if they don't have any insurance, simply explain to them, this can be out in payments. It doesn't matter. I'm not the one charging you today. Very simply, if the patient remains resistant to your attempts, the paramedics should proceed with a complete description of the illness or injuries that have sustained and potential complications. If they want to go against the medical advice and not go with you, some patients refuse care in opposition to all logic when confronted with clear and immediate danger. An example of this, they're having a heart attack and they still won't go to the hospital. These patients are deciding against a medical advice not to go to the hospital. The paramedic is advised to contact medical control for direction and advice. Be sure you have lots of witnesses to this, especially if you think that you're going to be back there in a little while doing chest compressions on them. And this is a standard form here, kind of an example of a refusal of care, figure 6.3 in your books. Destination. Generally, patients are transported to the closest appropriate facility, but however, the hospitals are becoming kind of more specialized. Appropriate medical facility may not be the closest. Example of this, if you had a heart hospital or a cardiac hospital or a neurological hospital that was specialized. Those may be all the way across the city. Advanced directives. Brings up a lot of topics. Development of new life-saving technologies, accompanied by questions of the quality of life in terminal illness and the prolongation of suffering. Questions were derived from the case of Carrie Ann Quinlan and the case of Nancy Cruzan. What is the quality of life? All of that has to be determined. Err in your patient's favor. If you're confused about a subject, very simply get medical control involved and explain the situation best you can and see where it goes to from there. Principles of advanced directives. Competent people can refuse medical treatment. Interests of the state are subordinate to the will of the competent patient. Healthcare decisions should be made in a healthcare setting as opposed to a courtroom. If the patient lacks the ability to make decisions, then the patient may assign a surrogate decision maker of her stead. Patient Self-Determination Act of 1990. The patient has the right to participate in and direct their own health care. Patients have the right to refuse medical and or surgical treatments, up to and including the use of life-saving or life-preserving technologies. The patient has the right to prepare an advance directive. The hospital has the duty to assist the patient with decision-making activities. And types of advance directives, we have living wills. It's a durable power of attorney for health care. Surrogate decision maker uses substitute judgment to guide the patient's healthcare decision, and this is considered a healthcare proxy. Do not resuscitate orders, which used in situations where artificial life support would be futile and death is inevitable. Paramedics are expected to honor a DNR order. Palliative care is acceptable, and that would be comfort care. And then physician order of life-sustaining treatment. Detailed description of the patient's wishes placed in the form of the physician's order. Confidentiality stems from a person's right to privacy. Liable, which is the first term we're going to talk about here, damaging falsehood written or printed and disseminated into the public. Slander, defamatory lies about the person are told to others. Breaches of patient confidentiality. Pretty much we have currently a federal mandate on this. Physician may breach a patient's confidentiality when required by law, and this would be after the subpoena of the medical records. Disclosure limited to that which is necessary to the issue. Limited disclosure. Only provide confidential patient information to those who have a need to know, and only to the extent that is needed. And the federal mandate is HIPAA, which is the Health Insurance Portability and Accountability Act. Provides for criminal penalties for inappropriate disclosure of patient information. Establishes a number of protections for the patient's right to privacy. And then last term here is going to be disclosure to law enforcement. And officers should be provided with information which is required by law. Patient's name and address can be shared. All other requests of information should be denied until the patient signs a release of information or a subpoena is served. Information dissemination. This is table 6.2. Obviously the paramedic, if they're under direct treatment, the ER, medical doctor and or RN, billing clerk, utilization reviewer, and this would be reviewer from the hospital or QI maybe, infectious disease RN, public health service, Center for Disease Control, and the media in case of reporting an outbreak, but then no personal information would be applied to that. Employment law. American with Disabilities Act protects those citizens who suffered hardships or discrimination from employers. Prohibits discrimination based on disability in hiring, promoting, training, and retiring. Title VII provides the employee with certain rights, freedom of religious expression, etc. Amendments to Title VII are Age Discrimination and Employment Act, Equal Pay Act, Fair Labor Standards Act, Family and Medical Leave Act, or FEMLA, and requires employers with more than 50 employees to provide employees 12 weeks of unpaid leave for the purposes of child rearing or childbearing. Conclusion. Acts, laws, and regulations that affect the paramedic intend to protect the paramedic or to provide the patient protection. Careful attention to these laws, both in letter and in spirit, will help the paramedic provide safe and effective health care. References for this chapter were taken from Professional Paramedic, Volume 1, Foundations of Paramedic Care, First Edition, pages 82 through 104 of Delmar Learning. If you have any questions concerning this, feel free to contact me. My name is Roy Smith, smithr@imsa.net, or 405-219-7613. Thank you.